Just as baseball fans relish statistics, so do Supreme Court watchers. How often a justice votes with the majority? How often in dissent? How often allied with this colleague or that one? With the numbers, a portrait takes shape to reveal a justice's power and role on the court. For Chief Justice Roberts, the portrait that emerged from the term that ended on July 9, 2020, was one of triumph. Of the term's 53 cases decided with signed opinions, an unusually low number, due to the postponement of cases scheduled for argument early in the COVID-19 shutdown, he was in dissent in only 2, fewer than any of his colleagues and his own record low for his 15 years on the court. The easiest way to keep track of the court during the term's 9 months was simply to look for John Roberts, finding him in the majority in decisions on presidential immunity, immigration policy, religion, abortion, protections for LGBT employees, and nearly everything else. He managed, at crucial moments, to navigate across the court's ideological divide. He maintained the court's focus when the COVID-19 pandemic drove the justices from their chambers and their courtroom, leaving them to hear cases not on a fancy internet platform, but over their home telephones. And as important as anything else was this. Under a hot election year spotlight, he kept the Supreme Court out of trouble. After the court handed down its last decisions on July 9th, 2 weeks later than usual, he was entitled to feel both relief and pride. It might so easily have been otherwise, as he surely knew. Had the 2016 presidential election turned out as most people expected, a President Hillary Clinton would have filled the Scalia vacancy, and Roberts would have found himself facing the prospect of near irrelevance. Ruth Bader Ginsburg, as the senior justice among 5 liberals on the court, would have been able to shape the course of events, leaving the Chief Justice a bystander. Of course, not every Supreme Court case turns on ideology. Most do not. During the term that included the 2016 election, the court decided more than half its cases unanimously. But when ideology matters, it matters greatly. The loss of a reliable conservative majority would have doomed 2 projects on which Roberts, with Scalia as a reliable ally, was making steady progress. Those 2 projects lay at the center of the national conversation, indeed at the heart of the country's struggle to define itself during the opening decades of the 21st century. One involved race, the other religion. Roberts's long-term plan was to change how the Constitution understood both. And now, with Donald Trump having filled the Scalia and Kennedy vacancies, he was in a position to achieve his goal. There had not been a case concerning racial equality on the docket for the 2019-20 term, but that was an anomaly, a fortunate one for any Chief Justice interested in his courts keeping a low profile, given the urgent racial reckoning that shook the country following the police killing of George Floyd, an unarmed black man, in Minneapolis on May 25th. Race would certainly be back, and Roberts was ready, even though he might not have been aware that an important new Voting Rights Act case had arrived at the court in April, filed by Arizona Republicans seeking to limit the use of the Voting Rights Act of 1965 to attack measures that result in suppressing the vote. It would be early fall before the petition made its way to the justices for action. The debate over public policy concerning race, voting rights, and affirmative action, to which he referred dismissively as racial balancing, had drawn Roberts's interest since his earliest days as a lawyer. In 1981, direct from a Supreme Court clerkship, he had joined the Reagan administration, where he was an eager participant in the administration's program to dismantle or at least curtail race-conscious policies across the government and in the private sector as well. Serving first as a special assistant to Attorney General William French Smith, and later as a lawyer in the White House counsel's office, he wrote strongly worded memos marshaling opposition to efforts underway in Congress to renew an expiring section of the 1965 Voting Rights Act, and to restore another section that a 1980 Supreme Court decision had undercut. These internal memos came to light in 2005 when President George W. Bush nominated Roberts to be Chief Justice, and they provided what little substance there was to the Democrats' tepid opposition to his confirmation.